It was soon followed by a parallel consumer protection case that took largely the same position. In both of those cases, those leading cases, the tribunal had not even entertained the competition law issue or the consumer protection issue at all. But then the question arose naturally as to whether, if a tribunal were to entertain them, would the way they entertained them be subject to scrutiny? In other words, merits review. And we know that that has been an ongoing question of whether the review is deferential or whether the review is highly non-deferential. Now, of course, this is not shocking. There is nothing antithetical between international arbitration law and the notion of public policy. After all, the New York Convention contains a public policy exception. The UNCITRAL model law provides for annulment on public policy grounds. Almost every modern arbitration law will do something of that kind. It must be said, though, that in international arbitration circles, it wasn't obvious where the stopping point was, the stopping point of EU public policy. And if you read those two decisions carefully, you will find the rationale for designating competition policy and consumer protection policy as EU public policy domains. The precise rationale in those cases could be applied to a great many other fields, though we don't have those cases yet. So you will imagine, of course, that the prospect of what might be full judicial review on the merits of one of these awards, and Advocate General Batley in the Genentech case so advocated, was met with sort of some degree of alarm in international arbitration circles. Now, thus far, I've identified two discrete developments that have in common an expansive or potentially expansive and robust concept of EU public policy that could not help but be viewed as a serious challenge to the international arbitration legal order, precisely because public policy is a defense to the enforcement of an arbitration agreement, is a ground for the annulment of an arbitral award, and a ground for the denial of recognition and enforcement to an arbitral award. Now, I referred a few moments ago to there being a third major development, and this one is broader, and this one is less easy to grasp, and you all know it because you've read Achmea. It's a development that's been brewing for a while, and I think likewise represents a serious challenge to international arbitration. And a lot of ink has been spilled and will continue to be spilled over the meaning of the autonomy of EU law and the EU legal order. This notion, like the notion of EU public policy, is not entirely new. I'll indicate why, but it has recently, Achmea certainly helped in that regard, achieved unprecedented resonance. Now, one thing I'd like to really point out about autonomy, even though I'm not sure I still understand it, and I hope some of the questions and comments will pertain to that. The notion of autonomy of the EU legal order initially arose in a completely different context than investor-state arbitration. A completely different one. And that context was the primacy of EU law and policy vis-a-vis member states of the European Union. That is to say, a domestic principle, autonomy. And we can read the term autonomy in the landmark decisions of the European Court of Justice, which are familiar to all of you. I'll do just a short bit of quoting. We all know that in Van Gendenloos, The court proclaimed the EU to be, quote, a new legal order of international law. And in Costa versus ENEL, the court, and I quote again, said, by contrast with ordinary treaties, the EEC treaty has created its own legal system. And the court continued, said, it constitutes an independent source of law. It didn't use the term autonomy, but I think it came very close to alluding to what we've now come to understand, if we understand it at all, what autonomy means. But I want to be very clear, and I don't think it's been sufficiently observed, that it's one thing for the ECJ to posit the autonomy of EU law vis-a-vis the law of its constituent parts. That's one thing. Certainly the US Supreme Court has done that within its federal system, and probably every federal system has posited the primacy of federal law over state law. But it is quite a leap to go from the autonomy of EU law vis-a-vis the member states of the EU to the autonomy of EU law vis-a-vis other international legal orders. I believe that it is entirely different. And that is something we need to talk about. This, what I call a leap from, if you will, autonomy vis-a-vis the member states, autonomy vis-a-vis other international legal orders, of which international arbitration is not the only one. And this crowd does not need to be reminded of that. Autonomy of EU law and the EU legal order received a frequent articulation in, as you all know, a series of opinions of the European Court of Justice in reply to questions by the European Commission as to whether the EU's entry into a given international treaty would be compatible with the EU's constitutive treaties. We could mention any number of them. Of course, a salient example would be Opinion 213 on the conformity with EU law of the EU's prospective accession to the European Human Rights Convention. And there, in that opinion, the court reaffirmed what it had said in previous opinions, and I quote, the EU can accede to a treaty providing for a court that would be responsible for interpreting that treaty and whose decisions would bind the EU institutions, including the Court of Justice, but those decisions could have no adverse effect on the autonomy of the EU legal order, meaning that a court of another international legal order must not have the effect of binding the EU and its institutions in the exercise of their powers or to a particular interpretation of EU law. Now, of course, for the ECJ to reserve to itself the power and authority to render authoritative decisions, and I'm going to get my second set of papers, reserve to itself the authority to render authoritative interpretations of EU law is nothing remarkable. But the ECJ went further than that in these opinions in two respects. And I think here we begin to see assertions that might be revisited, or at least understood for what they are. First, the court in these opinions, if I read the opinions correctly, and I stand to be corrected, of course, reserved to itself effectively not only the authority to interpret EU law authoritatively, which it had every right to do, of course, but also the power to interpret EU law altogether. In Opinion 213 and on similar occasions, the court asserted a monopoly over the interpretation of EU law. And this is shown by the court's repeated assertion, that the EU cannot subject itself to the jurisdiction of an international court or tribunal if that international court or tribunal, as is almost invariably the case, is incapable of making a preliminary reference to the European Court of Justice for authoritative interpretations of EU law when the need for an interpretation might arise. The court described in Acmea the preliminary reference mechanism as quote-unquote the keystone of the judicial system established by the treaties. And for that reason alone, said the court in opinion 213, that accession of the EU to the Convention on Human Rights would be, quote, liable adversely to affect the specific characteristics of EU law and its autonomy. Now, I personally know of no legal system other than the EU, again, if I understand the situation correctly, that purports to disallow foreign courts from interpreting and applying that legal system's law in cases that properly come before them. You know, legal systems do not generally object to their law being given effect by the courts of other jurisdictions. They don't. They don't. So why does the ECJ show such discomfort at courts of other jurisdictions interpreting and applying EU law? You would think you think it might welcome that. Of course, at the risk that the interpretation might be misguided, it might be erroneous. But the very fact that a foreign legal system will give effect to a jurisdiction's law in and of itself is not viewed in most legal systems as a negative. But then, of course, you must wonder what a court or tribunal under a bilateral or a multilateral investment agreement to which the EU is a party, what is it to do when there arises in a dispute that comes before a question of the interpretation of EU law? Advocate General Watley, I need to remind you, argued that an investor-state tribunal can be considered a court or tribunal of a member state, and that would solve the problem, but we know the Court of Justice in Acmea would have nothing to do with that. Nothing to do with that whatsoever. So, if you will, the Commission and other member states in Opinion 117, in the hearing in the opinion to which you have alluded, Nikos, suggested that autonomy might be relaxed when it comes to investor-state agreements into which the EU itself, rather than a member state, might enter. Now, I honestly mean, and for the rest practically of this talk, I wish to understand better what autonomy of EU law signifies in the application of international treaties, investor-state treaties, to which the EU is a party. I will point out to you that CETA has tried to facilitate our understanding a little bit or limit our concern. Article 8.31 says an investor-state tribunal may consider as appropriate the domestic law of a party, that would include the EU, as a matter of fact, and more importantly, and I quote, that it shall follow the prevailing interpretation given to the domestic law by the courts or authorities of that party. I want to just mention that I don't still know whether a CETA tribunal is an arbitral tribunal or a court, and we will need to talk about that. But that might make a big difference with respect to the willingness of the EU to challenge awards. I hesitate, or I should say I'm actually inclined to think it might make a difference. Before we go further, though, I want to pause to observe the difference between Opinion 213, in which The autonomy of EU law is featured on the one hand, and the Achmea decision on the other hand. Both of them, the opinions collectively, on the one hand, and Achmea on the other hand, addressing compatibility with EU law autonomy. I don't think it's sufficiently observed that the opinions allow a determination by the court of the compatibility of a treaty with EU law before the EU enters into it. It's, if you will, it's sort of a prophylactic review. And it avoids, I guess, a question of the adequacy and the validity of an assertion of jurisdiction by those tribunals. But in Achmea, the court condemned the treaty in question, the bit, and, if you pardon the expression, dishonored an award emanating from that well after the member state had entered into the treaty and incurred an international legal obligation to respect it. I think the timing difference between an opinion, pre-accession opinion, pointing out incompatibilities, should there be any, and on the one hand, and, if you will, a rejection of the validity of a treaty after it has been entered into and has created, at least at first glance, international legal obligations, is yet another one. Now, it's clear, and it's true, that the court in Achmea was at pains to distinguish between intra-EU bits on the one hand, and the EU's own investment agreements such as CETA, Singapore, Vietnam, Mexico, on the other. As for the latter, and this is a concession, or so it appears, the competence of the EU in the field of international relations and its capacity, this is Achmea, to conclude international agreements necessarily entail the power to submit to the decisions of a court which is created or designated by such agreements as regards the interpretation and application of their provisions. And thus far, to that point, Achmea is reassuring, is quite reassuring. But as you also know, as in the various opinions that it had rendered, the court attached a somewhat worrisome proviso, provided that the autonomy of the EU and its legal order is respected. So we have a degree of reassurance coupled with something along the lines of a warning. Now this proviso, if you will, provided that the autonomy of the EU and its legal order is respected, like all provisos to international legal commitments, is to be taken seriously. And as the EU becomes more and more an actor on the international stage, particularly in international investment law, the need to unpack the meaning of EU law autonomy is becoming increasingly urgent. We know for certain that the notion of EU law autonomy after Achmea is meant to have jurisdictional consequences. Strictly speaking, Achmea was a jurisdictional ruling only. And we can hope that, as the Commission appears to have conceded in Opinion 117 hearing, the proviso just quoted will not call into question the jurisdiction of CETA tribunals, depending, of course, on Opinion 117's outcome, and other tribunals to interpret and apply EU law. So Achmea was not a substantive law ruling, although there was substance to the dispute, obviously. But, if you will, there is the possibility that an investor-state award will implicate not just jurisdictional issues, but also substantive law issues, raising the prospect of an award that condemns and EU law